certified copies of my birth certificate, ownership of fictitious name, and all the PPSR notices as well.
Okay.
They were all attached to this letter.
Okay, so in relation to the common law court, you have ordered your hard copied, sealed documents from the UK, correct? And then you've got them signed off, witnessed as original copies of those, yeah?
Correct, exactly. Okay. So I got copies from the UK sent to me, and then I went to a JP and had them copy them and then certify them as original and true copies.
Brilliant.
Yeah. B, does the court acknowledge my standing as principal and beneficiary of the Sescovi Trust, known as Alex Stefan, all caps? If no, please state your reasons with supporting evidence.
You're turning this court case into a bit of a probate court there, I see, Alex.
Yeah, it sounds like it, doesn't it?
Not a bad idea.
If the magistrate chooses to proceed with this case, does the magistrate agree to act as trustee for the Sescovi Trust, known as Alex Stefan, if requested to do so? So I can request the judge at any time to act as trustee, in which case he becomes liable for any actions by the plaintiff or the accuser in this case.
Well, if the truth be known, with the way that they operate, Alex, is that Alex Stefan, as I see it in C in all capitals, is actually the judge. He is Alex Stefan.
You mean the all capitals or this lowercase?
No, all capitals. So, for example, is Alex Stefan here today? Well, that would be correct, and that would be you, sir.
Yeah, good point. Because he's the trustee.
Yeah.
Is that why?
Yep.
Yep.
And I mean, that's all good, but I mean, requesting, etc. I mean, let's think about that as king. You are the principal, you are the executor. So if it is that you wish for him to fulfill his duties, which he should, because that's his position, well, perhaps you might need to use a different word. I know you're trying to be a humble king, which all kings are quite humble, but perhaps a requirement. You are required.
Yeah. Good point.
Suggestion.
Yeah. Okay. Required to do so rather than requested to do so.
That's right, because when you think about the word requesting, that would come from someone lower looking up higher, requesting or something along those lines. That's the way that I feel about it anyway. Perhaps
required is a word that didn't come up when I was thinking about, because I was thinking about what you were saying, and I was thinking if I thought the word demanded kept coming up, and I thought, no, I don't want to sound like I'm demanding something, but required is actually a good word. I should have used that word.
Well, a lot of people, they either opt for requiring or demand. Now, require is probably a less sort of a forceful way to have something done. And to note as well, like a man uses the word require. A person can never really use the word require, whereas you hear persons using that often, police officers and others as such, but they really cannot be, because it can only come from a man. And remembering for any females watching this, that God made man in the image, both male and female. So when I say man, I'm not leaving you lovely ladies out.
The word man actually does include both, but yeah.
Exactly.
Okay, so D, does this court acknowledge that imposing a legal name upon a living man is known as unlawful conversion and is a crime and will be prosecuted?
Okay, could you elaborate there on unlawful conversion?
Yeah, so unlawful conversion is basically when they take you as a living man and they adhere the straw man name to you. There are other instances of unlawful conversion as well. For instance, taking a private car and converting it to a car that is used for business, such as a taxi. And saying to the person that goes to the office to get their car registered, oh, your vehicle is actually a commercial vehicle, therefore you need to pay this rate. And then I would say, no, it's not a commercial vehicle. It's a private vehicle or car. And they say, no, it's a commercial vehicle. And so them converting you into something else for the purpose of making a larger sum of money is what's known as unlawful conversion.
Okay.
Yeah.
And it's interesting that you say that, because it makes me think, when someone would be pulled over by the trading company, a police service, for example, they perform such a thing like that, in relation to a driver and a traveller. And interesting to note, when you do register a car, mine is private. It comes under private. But we all know the undertones to all of that stuff, so we won't get into that. But also another word could be misrepresentation. Now,
yeah, it's the same thing. Yeah, it's misrepresentation, essentially.
Well, I'll give a little a word glossary on misrepresentation for those that are listening. Misrepresentation is the giving of false information by one party or their agent to the other before the contract is made, which includes them to make the contract. If a person makes a contract in reliance of a misrepresentation and suffers a loss as a result, they can cancel the contract or claim damages, or both.
Yep. Yeah, exactly. Okay. So the next point, E, does the court acknowledge that the name Alex Stefan, all caps, is copyrighted, and said copyright is exclusively owned by and is the private property of the living man Alex Stefan under common law, and no permission is granted to any person or entity to use said name for commercial gain or any other purpose? If no, please state your reasons.
Okay. Now, in respect to that, now a lot of people that may be watching would think, well, hang on, you're not the legal owner of that name. It would be owned by the one that's put the autograph and seal next to it. But there is more to that, isn't there, Alex?
Yeah, so I've actually registered the ownership of that name with the common law court and also with the PPSR. So it is actually a registered, it's a registered ownership. So.
And also with contract law, there's a few principles that come along with contracting, and one would be a full meeting of the minds and transparency. So if there's anything that is not expressed in that contract, it would then become voided. Now, with the common law courts and the registration of the birth certificates, etc., it goes to a place when it lands in the common law courts in a book of deeds. And then there's a fictitious name registry there, a book of deeds as well, in correlation to that. So because Alex has done such a thing, which has brought it to light, that the owner, which would normally be the birth, deaths and marriages registrar, because he committed fraud upon the inception of such instrument, it is voided, and the owner is now Alex Stefan.
Exactly.
Taking ownership of the person. That's a big, large corporation with a bit of credit in there, Alex.
Okay, so that's the end of that section about establishing my my lawful standing. This section is brief. It's called Private Settlement Agreement. And with regards to the letters I sent to the complainant, does this court acknowledge the maxim of silence is deemed to be acquiescence, a concept that was upheld in the case of Golden Inns, blah, 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 in 1993. So basically, if they can acknowledge that silence is deemed to be acquiescence, then they would have to also acknowledge that all those letters I previously sent to the department are actually lawfully binding, and there's no case. They'd have to throw it out.
Very good point.
Okay, so the next section is called court procedure. So A, I require details regarding the magistrate's bond and insurance policy. Okay, and the reason for that is a bond is basically them putting up cash. It's like a bond when you rent a house. If you do damage to the house, the landlord gets to keep your bond or part thereof. In this case, if he damages me, I want to know what his bond and insurance details are so that I can keep the bond.
Yeah, exactly. And I mean, anyone that works in a public service sector is bonded and should be bonded. And if they are not bonded, well, they cannot be performing such a such a task.
Yeah, exactly. B, I require details regarding the bond that has been lodged by the complainant with the court. If no bond has been lodged or details cannot be provided, please state your reasons with supporting evidence for any claims. So usually what happens is when someone brings an action against you in a court, usually it's the lawyers also pledge a bond as well. Because if you're found innocent and you've been sitting in a jail for the last 2 years while this court case has been going on, you need to be compensated. But also bear in mind that compensation doesn't happen automatically. It has to be forced. And a lot of people that get freed from jail after such long, drawn out court cases and eventually found guilty don't even realize they can actually go after the judges and the prosecutors and actually get compensated.
Okay.
C, will the court respect my right, my right and require the complainant to certify my right to subrogation in this manner? Subrogation is essentially the ability for me as the living man to take the place of the prosecutor. This is very common in insurance. What it essentially means is, I'll give an example that is common in the insurance world. Let's say my tent burns down and it's because the fireplace was faulty. The insurance pays up and then eventually I'm able to get compensated by the company that manufactured the fireplace. So in essence, I've been paid twice.
Okay. I've got a question about that. I mean, because they're bringing in an instrument, right, which would be from that trading company, right? So when they bring that instrument into the court, etc., that creates value. That creates credit. And because that credit would not have been created if it wasn't for you, Alex Stefan, with a colon in between, therefore you are already bringing something to the court in value. Now, I'm a bit blasé on subrogation rights. However, there is one in particular video that explains it quite well, and I haven't seen it for a long time, but I might even link that with this video actually, because it's quite a powerful tool to use in a court if you wish to go in there.
Yeah, that's right. And actually, the only reason I'm putting this in is because I just want the judge to know that I'm aware of this and I may use it. He doesn't actually get a choice as to whether he allows me to do it or not. It's actually, it's a given that if I request it, it's to be acknowledged.
Yeah, I'll be certainly a little bit mindful of bringing your claim into my court with what I've read, Alex.
Okay, D. I require that the court confirm which law dictionary is to be used to define all words used in this case, as well as any written documents. So as we know, one of the common ways they entrap people is by using words that have a definition other than what you think it has, known as legalese. So I want confirmation ahead of time as to what exactly, where exactly are we going to define all these words.
That's right. That's a really good question too, because you're speaking of legalese, and we know that there's a few different law dictionaries out there. You know, we've got Black's Law, we've got different editions.
Yeah.
Which would think they're probably moving the goalposts each edition. Who knows? But they've got Bolivar's, etc. And then there's the common, Oxford Dictionary. And then we've got etymology. So really, words and their interpretation are very important, because if you look back in history, in the old days, there's all these spellcasters, etc., and druids and whatnot. And I think it's very prevalent today. And it's always really good to get to the origin of words. So that's a good question.
Yeah, so I want the judge to tell me before I even walk in what dictionary are we using to define all these words. I don't want to get entrapped.
Okay, and this document here, would this be something that he will be responding to you before that date of 18th of September 2020?
Correct. Yep, correct. Well, he can choose to ignore it, in which case he'll regret it, because I'll show you what's about to come.
Right.
E. I require the court to confirm which styles manual it relies upon. If this cannot be confirmed, please state your reasons with supporting evidence for any claims. So a styles manual is basically points out, similar to what we're talking about with the all caps name. So if he says, oh, nah, the all caps name doesn't mean what you say it means, he's already told me which styles manual you would use, and I can then refer to that styles manual in the court and show him, and that's a styles manual that he told me he uses, so it should be fine.
And styles manual pertains to the grammatical layout and style. Well, more so the style that's laid out in the grammatical format.
Correct.
So that's very important. I think currently we have Australia's Style Manual 6th edition there. And while we're on the subject, Alex, we'll point out page 516 of that Styles Manual, which has a subheading military, I think it's military something, and it goes into to state that your Mr. and your Mrs. is the lowest rank of the military. So we've got that there. We've seen words of command and everything else. I've mentioned, not at post, being a post box on your property, being at a military post, etc. So it certainly looks like we're in armed conflict here. But that's another topic for another time. But very good question. Very good question indeed.
Okay, so F, does the court acknowledge and confirm that the rules of civil procedure and any related civil or statutory acts only apply to civil or statutory entities and are not binding upon me, a living man, under common law? If no, state your reasons. G, does the court acknowledge and affirm that any documents required by the court to be completed and or signed by Alex Stefan will not constitute an agreement or contract of any kind with the Magistrates Court of Victoria or any other entity? So what they do, and I've already had a look at their website, if you want to put in a notice to defend and any other thing, anything you want to do with the court, usually they require you to sign documentation. And I went through and I looked at some of the small print, and the notice to defend pretty much said that by signing this, you agree to abide by the rules for civil procedure, and it gives the actual act and all that sort of thing, which automatically puts you under their jurisdiction before you've even walked into the court.
That's right. And it goes from a civil procedure, then there's interpretations on this act, they bounce to this act. So I mean, who knows?
Yep. So I want confirmation. I want them to tell me that if I choose to sign something that they want me to sign, that it's not going to in fact constitute an agreement. Because I don't want to agree. I don't want to contract with them.
Of course not. Of course not. And perhaps also you may want to put there it should not be seen as tacit conduct to any endorsement of any instrument that is signed, being the
good point.
Cartel, aka courts.
Correct. Exactly.
Because for those that aren't aware, the magistrates' courts and courts in general are just nothing more than a banking cartel. They're actually trafficking children. They're child traffickers. And when I speak of children or childs, we're speaking of infants. We're speaking of persons and birth certificates, which a birth certificate pertains to the infant. So that there, by definition, is child trafficking, which is a war crime, and et cetera, et cetera.
Correct. H, does the court acknowledge that Alex Stefan reserves his rights as a living man under common law not to contract with any person or entity, including but not limited to the Magistrates Court of Victoria? Okay, so then there's a small section on constitutionality. Does the Magistrates Court acknowledge the Commonwealth of Australia Constitution Act 1900 as the supreme law of the land and the final authority over this case in particular? They may not acknowledge it in general, but I want it acknowledged over this case, particularly the statement that the people are the supreme, absolute, and uncontrollable authority. Does the magistrate acknowledge that laws which go against the Constitution are null and void, per Marbury versus Madison 1803? Does the court acknowledge that when a court violates the clear and unambiguous language of the Constitution, a fraud is perpetrated and no one is bound to obey it. That's a quote from State versus Sutton.
Ooh, another good one. Could we just pop it up? Go up one for a second
Yep.
there, Alex, if you could, please. Now, with the what do we got there? We've got the Constitution there. Absolute uncontrollable authority. The people are the supreme, absolute, uncontrollable authority. Now, many people would quote that, speak about that, feel in power in that. But there's something to point out there. The people. Okay. Now, in law, laws work in presumptions, and as far as the trading company, Australian government, or your company which you live in, which would be Queensland, Victoria, etc., you are presumed a person. So there is no uncontrollable authority. However, in the case of Alex, Alex has corrected and done a lot of work correcting records and rebutting certain things and standing in the private as a man asking, as you can see here. So for those that believe, just by the simple thought, that you know who you are, etc. There's a lot more administration that needs to take place in order for you to be recognised and have that standing capacity in the system to actually have that authority to stand on. Thanks,
Yep.
Alex.
Yeah, no worries. Okay, so D, does the court acknowledge that a right cannot be converted into a crime per Miller versus United States? Okay, so they can't say, yeah, well, you do have that right, but you've also breached the Land Act, so therefore, you need to leave or something. You can't have it both ways. Like, I can't have a right and then not have a right.
That's right, because when we speak of a right is something that can never be taken.
Yeah.
So if it's there, it cannot be not there.
Yeah. Okay, so the next section is called legal and lawful standing of the court. I require that the court confirm that it is or is not a registered corporation and is in no way operating as a corporation and does not have an ABN number or other company number registered with any organisation in Australia or overseas. If this cannot be answered, please state your reasons with valid supporting evidence for your claims. If the answer is yes, please provide details. Now, I already know they have an ABN number, but I'd like to see what they say. I require that the magistrate presiding over this case confirm whether she is an employee of any corporate entity, and if so, which, and whether the magistrate is a shareholder of any entities that may benefit from his or her capacity as a magistrate, for example, through private prisons as a shareholder, and declare any potential conflict of interest. If refusing to answer this question, please state your reasons with supporting evidence. So I want to know, first of all, whether the court is actually a corporation, and whether the presiding magistrate is actually has any conflicts of interest that he might benefit from my case or any other case for that matter.
That's right.
And many of them do. Next section, legal and lawful standing of the complainant. Does the court acknowledge that the entity known as the department is a corporate entity having ABN number, blah, 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 and that fictional entities have no power over the living as per these two cases here?
Ooh.
The Supreme Court case of Penhallow versus Danes Administrators, and the 1952 Supreme Court case of Rundle versus Delaware and Raritan Canal Company, which stated that a corporation cannot sue or otherwise contend with a living natural man or woman.
Exactly. Beautiful. I like those two cases there. I'll have to get them ones off you.
B, does the court acknowledge that inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons? This is the rule. Artificial persons can only interface with artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. So they cannot say that the department has authority over me or has authority equal to me. They are subordinate to me as a living man.
Okay, so we've got artificial persons because there's quite a number of different persons they've created in the fictional world, haven't they?
Hmm. Yep.
And that's right, because if we look at the hierarchy of things, on a simpleton scale, we've got creator, whoever that is, whatever you believe it is, creator, he created you. We've got man, we've got government, we've got corporations, we've got persons. So yeah. So there you go. So all you men out there, being the female and male, there's something going on. They pulled the wool over your eyes, and you need to correct the records immediately.
Yeah, and I'm about to show you another document that I've sent through to all the government departments as part of that process as well.
Oh, brilliant. Fantastic, Alex.
The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. And this is the Penhallow versus Daines administrators.
Okay, I noticed when you make certain claims, or rather, they're not claims because you're asking the question, but when you are asking these questions, you're sort of stating the obvious, but you've also got something to back up everything that you're saying, which is very important, I believe. So it's great.
Yeah.
You must have been studying hard there to find all those case laws that pertain to the certain things you're asking, or you just had them on record there over your years of experience?
I just hear them through other videos and find them online and all that sort of thing.
Yeah.
I actually have a document that is about 100 pages long with court cases on it that I was able to get. Yeah.
You'll have to send that over to me, mate.
Yeah. I'll show it to you later. Okay. Okay, so now regarding the judicial powers of the court. Does the court acknowledge that any order by a single magistrate is not a judiciary order, but is a violation of common law as stated in the Criminal Code Act 95, Section 268(10)? So it is actually a crime for them to impose statutory, for a magistrate to impose statutory law into the common law jurisdiction, to basically mix the two jurisdictions up. They shouldn't be doing that, essentially. Does the court acknowledge that there is only one judicial power in Australia, not different rules in each state, and that the Commonwealth remains one and indivisible, based on the Cable Principle, Section 71, which is a High Court ruling of 1996. So they can't say that, well, Victoria has this rule, and Victoria needs to wear masks, and New South Wales doesn't need to wear masks. That doesn't actually work. Yeah. Okay, next point. Does the court acknowledge my request for a trial by jury according to the Constitution, Sections 79 and 80, and that refusal of a trial by jury is obstructing the course of justice according to the Crimes Act, Section 43? Does the court acknowledge that unless and until a jury trial is held and any event of a judicial nature occurs, no costs are payable by either side on proceedings, regardless of any direction from any parliament? In other words, only a jury can award costs as determined on August 2001, penalty of 25 years in prison for the solicitor and the judge who commit the crime of cost orders. This is taken from Slavery in the Criminal Code Act, Section 268. And also there are references to this sort of thing in the Habeas Corpus Act of 1640 regarding cost orders.
So the cost orders,
magistrates,
would that be in relation to, you having to rebut and clear up a presumption when a trading company is, trying to place you in their jurisdiction to basically fish you up the bum?
Yeah, well, basically what happens is, let's say at the end of the court case, let's say I lose the court case, right?
Right.
And then the guy that is accusing me asks the judge at the end of the day and says, we would like the magistrate to award costs to us to cover the costs of today's proceeding. And typically what will happen is the judge will award costs to whoever wins the case, and it's usually pretty hefty. You're looking at above $10,000 at least for a one-day court case. So I'm basically telling them here that even if I lose, if you were to, somehow find that I need to leave this land and blah, 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 awarding any costs is actually illegal. So, yeah, I just wanted to point that out to him.
Okay. And that's, would that be in conjunction at all with, your time, if it is that you did walk into that court to, be present as an executor to this matter?
What actually I have in the previous letters that I sent to the department, I've written in there that I will be charging them for my time if they come and visit me, if I have to go to court. I already put that in there. So I don't actually need the judge to award anything. I already have it in the contract.
Okay, yeah, fine. So that's across the board. Yeah. And no matter whatever dealings with them, that'll be $500 an hour minimum charge an hour. Gotcha.
Yeah, that's correct. And I will then invoice them after the case. Let's assume I win, or even if I lose, actually, I'll still invoice them either way. And if they refuse to pay, that's when I'll take them to court.
Well, you won't need to be doing that because I'll give you another way you can do that without any courts.
Good. That'd be nice.
And what I'm doing in the meantime, I'm going to try to bring up this international law, which pertains, I think, to a treaty. It's in relation to any trading companies that say, for example, a local council come into me trying to tell me I've got to do something. Ultimately, I'm going to rebut that, et cetera, et cetera. But that takes time, that takes energy. And we know that there is the most important and the most valuable thing that we have in this life is our energy and our time. And to give that freely, that's bad business. I'm not a silly man.
Exactly. And I'm actually in the process of doing this same administrative process with Victoria Police. I'm basically telling them that if they can't demonstrate and prove to me that I have to give them my time for free, from henceforth, they'll be paying. We can do a separate video on that, and I can actually take you through those letters and show you exactly how that works as well. But I will be charging the police every time they take up my time by pulling me over and all, whenever they stop me, they'll be paying, both corporately and individually. And I actually am getting a sign made up, which I'll have on my car as well, so that it'll be on the driver's side and on the passenger's side doors. And whenever they walk up to the car, they'll be able to see that sign before they even start talking to me. So I don't even need to say anything. I just open the window, go ahead and do whatever they want me to do. Give them my driver's license or whatever the thing is, and I will be recording everything, of course. Always record everything on video, and I'll, before we even start talking, before I even give them my license, I'll be getting their details, and they need to give those to me, and that's actually on the sign as well.
Well, that's the thing. I mean, a maxims of law, an old principle in law would be knowing with whom you deal. Now,
exactly.
A police officer in this sake of description would need to provide, proof of claim to who he is. So, one would think a badge, right? A badge, his badge number and credentials. One would also think of perhaps a business card that correlates to that badge. And then you'd want a driver's license, because I don't believe they have any indemnity, and they are fully liable, because as soon as they approach a man, they're committing fraud, and thus anything fraudulent voids any contract. So if there was any indemnity or any insurance, it would be voided from that point.
Yep.
Now, in relation to what I mentioned earlier, I did find that, and I found it inside of an agreement, which is layers of law that I created between the local council, which I'd know as a UN installation. It's the I for Indiana LO Forced Labour Convention of 1930, number 29. Forced or compulsory labour is, quote, all work or service which is extracted from any person under the threat of a penalty and for which the person has not offered himself or herself voluntarily.
Mm-hmm.
So thus there's made mention of a person, but being the man of the person, which would be the Shoals Daniel Lucas State, I'd, in that acting capacity, or not acting capacity, in the man of the office, you know, you can use that because that's what they're bound to, because they're a signatory to it, and they've ratified that.
Yep, exactly. But let's move along. We'll do a separate video, I suppose, if you like, on that whole traffic thing, and I'll show you what I have on that, which might help some people as well.
Sure.
Okay, so does the magistrate acknowledge that it is unlawful to deprive people of their rights under colour of law? Does the magistrate acknowledge that it is an act, that if an act or statute is beyond power, it is invalid ab initio, which means from the beginning, and that courts must respect the call made by people under common law, and what is clearly unlawful in a statute. Now, this is per an actual court case.
Fantastic.
Yeah,
question.
I guess it's...
Now, before you go back up a little bit.
Yep.
Just go up a little bit. Fantastic. Now, there's mentioned there under colour of law. Could you just give us a short brief of colour of law?
So wearing a mask is there's a new rule out that says you have to wear a mask, and if you don't, I'll give you a fine. That's not a law. It was never passed by a parliament. It doesn't have the standing of law. If it's a rule or a dictate, then it's not a law, it's voluntary. And any fines you give me are being given under colour of law. In other words, you're making it appear as though it's a law. You're treating it as though it's a law when it's not a law.
So they're sort of pretending, much like they're very pretentious when it comes to government. They've got that mask on as a de facto, which de facto means really invalid. But if people put belief into it, well, it's as good as, you know, do as you're told. Yep. So the colour of law, so regulations, directions, even statute, etc. I mean, you know, really, that's all just the colour of law. So no one really has to obey.
Yeah, exactly.
Wow.
So let's assume, for instance, that it's agreed that I am a living man under common law, and then the judge says, yeah, but the Land Act says that you can't camp there. That's essentially enforcing a supposed law on someone who the law doesn't even apply to, or the rule or whatever. That's another thing as well. Like, just imagine that a New South Wales statute were to be applied to someone who lives in Victoria and say, well, that's the law. Well, it may be the law in New South Wales, which means it doesn't apply to me. It's not a law in Victoria. So that's another example of applying a law under colour of law or a statute or whatever.
Okay, and one making a claim or making an allegation that, you know, that law, you know, is you have to abide by this law. Well, again, the principle would come back. Well, if you're making a claim, the burden of proof relies upon yourself. So show me in your law that you're claiming that I have to follow that states that a man is obligated to adhere to these laws. So in essence, I mean, you know, as king, as you are, and asking, you know, these guys are in a bit of a pickle. Go on, Alex. Fantastic.
Okay, so now we come to the actual agreement. So let's see what this says. So let it hereby be noted that the magistrate and the Magistrates Court of Victoria shall produce proof of claim within 21 days upon receipt hereof, with the affidavit and attached supporting documentation as aforementioned, or magistrate and Magistrates Court Victoria shall, as regards jurisdiction and the private settlement agreement, admit and agree that the non-response by the complainant to the attached letters, which I showed you earlier in this matter, constitutes their acquiescence. Number 2, that the attached private settlement agreement is binding and that the court has no right to interfere. Number 3, admit and agree that the magistrate, triple X, and the Magistrates Court of Victoria have no jurisdiction in this matter over the living man, Alex Stefan. Admit and agree that all laws which are not common laws such as the Land Act 1958, do not apply to living men and women under common law, and that corporate government agencies, such as the department, have no authority over living men and women. Agree that where there is an inconsistency between a law of the Commonwealth and a law of the state, the law of the Commonwealth shall prevail and a law of the state shall be invalid to the extent of the inconsistency as set out in section 109 of the Commonwealth Constitution Act 1900 UK. And agree that the magistrate and the magistrates court are bound by covering clause 5 of the Commonwealth of Australia Constitution Act 1900 UK. And as regards the above request for further and better particulars, this is the request to the court itself. Agree that the magistrate and the court knowingly, willfully, and intentionally failed to present proof of claim within the time specified and allotted herein. Agree that the conditions required in this notice of objection are not frivolous or vexatious, and agree that to be prohibited from taking unlawful action or issuing any orders based on the Land Act upon the living man Alex Stefan. Agree to be prohibited from taking unlawful action based on any law that is not a common law against the living man by way of any penalty, order or lawsuit or any procedure. Agree that the magistrate and the court may not attempt to perform any act which is unlawful. Agree that any such attempt may constitute a breach of section 43 of the Crimes Act. Agree that the living man, Alex Stefan, has and retains his right to claim damages as a result of any adverse or harmful effects upon him brought about by the actions of the magistrate and the court. Agree that the magistrate and the court and its employees, agents or representatives will be personally and corporately billed for my time to respond to, address or appear by phone or in writing or in person, and agree to pay at a rate of $500 per hour per person plus $500 per hour per organisation in blocks of 1 hour, with the minimum charge being 1 hour per person and per organisation. Invoices will be sent to your place of work and are strictly payable within 7 days by direct deposit. You also agree to pay late payment fees equivalent to the original amount for every 7 days that the invoice is overdue. You also agree that that late payment will result in your credit file being adversely affected and debt collection procedures will commence for any invoice that falls more than 30 days overdue. This is pretty much the same thing I sent to the Department of Environment as well. 15, agree that this constitutes that the magistrate and the court may reject this consensual agreement by way of providing the requested sworn affidavit and supporting documentation within the time stipulated in this agreement and in no other written or verbal manner. 16, the magistrate and the court agree that simply doing nothing within the specified time for response or providing answers to the above points which are incomplete or evasive constitutes their commitment and agreement to the aforementioned terms and conditions of this agreement. You'll notice that a lot of these are quite similar to the previous ones that we went through with the department. 17, agree and acknowledge that Alex Stefan has and retains the right to represent himself in any court proceeding and that this right will not be abridged. And I say that because in many cases, when you start giving them a hard time, the judge will actually say that he will order someone to represent you and he'll order you essentially in layman's terms to stand down. I've seen this happen a number of times where people representing themselves have been actually assigned a solicitor against their will. Yeah, so it's not a pretty situation.
Okay, let me have a look. Stefan has and retains the right to I'm reading that as represent. So I'll change that word to present because there is no representing with you because you are man. There's nothing.
Yeah, good point.
Unless they want to take away your temple and there's your soul.
Yeah,
on that level.
Good point. That's a very good point. I'm going to highlight that. Yeah.
And that also can be something you could mention in a court if you're over there. You're not here representing or representing yourself. You are here and you are present.
Yes, that's a good point.
Special appearance today, but as I said before, court is not my forte, so I will not speak of anything that I am not familiar with myself.
Yeah. Yeah. Well, the idea initially when I did this was to not even get to court. So you don't want to go to court. You want to try to get this sorted without going. But the problem is if no magistrate is assigned to the case until the day before the case, and the only person that's going to read this is the registrar. And when I spoke to them on the phone, he said, "Oh yeah, when we get it, we'll just put it in the file along with all the other documents for that case, and then the day before, we'll give them all to the magistrate that's been assigned to the case."
Yeah, I see.
So no one's going to read this most likely until the day before the case.
Yep, and that's right. You know, that's something that you're doing right now, which is fantastic. You know, you've got a fair bit of time between now and the court date. So if you get that in sometime midweek this week, you'll certainly adjudicate this.
This has already been sent.
It has. Fantastic.
Yeah.
That's right.
Yeah.
Now, in relation to what you mentioned about the magistrate and not knowing who that could be, I'm just trying to think.
I came up with an idea. So I've already sent an email to the court, and I said to them, okay, I understand that the magistrate hasn't been assigned. Could you please give me the list of all the magistrates from the Shepparton courthouse? And I'm just going to address it to all of them.
Yeah, fantastic.
Yep. So this is
I was trying to recite over my mind some of the times I've had to, you know, I don't go to court, but going to court, I deal with it from the office. I'd never step foot in there. Hence why I can't speak about, you know, presenting myself in the court because I don't go there. I'm just trying to think of the clerk of the court and then the registry. I'm pretty sure the clerk of the court is the boss of the court in the court room. However, the registrar is perhaps the principal of that organisation, thus would be responsible for its agents, and that including the magistrate. I would presume that'd be something to look into, though.
I asked him that. I said, well, can I address this to the registrar? He said, well, there's 27 of us.
Oh, shit. Well, that makes it a bit tricky, doesn't it? How does that work?
Yeah.
27.
I don't know. Yeah. So anyway, I'm just going to address it to all the magistrates. This is the first of 4 letters that I'm sending them.
And you mentioned 4 magistrates.
No, they've got. I'm not sure how many magistrates there are at that courthouse. There's probably more than that. But I'm going to get their names, and in the second, third, and fourth letters that I send, they will all be addressed to all of the magistrates in that courthouse.
Brilliant.
Yeah. Okay. So the next section, as regards to constitutionality and my lawful standing. The magistrate agrees and acknowledges that the living man Alex Stefan is not a legal entity and is therefore subject exclusively to common law and has broken no law that he is bound to abide by. The court acknowledges that the assignment of the legal fiction named Alex Stefan to the living man, known as Alex Stefan, is an unlawful conversion and a criminal act.
One sec. Going back to 18 there, to common law and has broken no laws that he is bound to abide by, which will be found within the commands of his heavenly Father, which is in the King James Bible 1611.
You could say that, yeah.
That's what I would say because, but that's each to their own, you know, and that's the beauty of it all.
Yeah, I'm just saying common law in general, which would also include that. So, yeah.
Yep, cool.
Anyway. Okay, 20. The court acknowledges that the legal name Alex Stefan is copyrighted and said copyright is exclusively owned by and is the private property of the living man Alex Stefan under common law, and no permission, that should have a D there, spelling mistake. No permission is granted to any person or entity to use said name for commercial gain or any other purpose. As regards the legal and lawful standing of the Magistrates Court of Victoria, the court agrees and acknowledges that it is not able to provide evidence of its lawful standing as a valid court with jurisdiction over this matter, and is not able to confirm and provide evidence of the absence of any conflict of interest in this case. That's regarding the judge.
All right.
As regards the legal and lawful standing of the complainant, the court agrees and acknowledges that the complainant has no lawful authority over the living man Alex Stefan, and the court agrees.
In
Yep.
relation to that,
Mhm.
you perhaps could attach Appendix A, marked A, and have that at one of those private agreements there for that point, because they've already said to you that they have no authority. It's already agreed. Would you agree? So what
Yeah.
you state there, and you always make a claim or ask a question, normally have something to back that up. So that'd be a lovely thing to have it back up, because it's an agreement where they, the complainant, have agreed that they have no jurisdiction whatsoever.
Yeah, you not only that, you know what I left out in this entire letter?
What is it?
I realized after I sent it, I actually have already sent an affidavit to the department before I even got into any of this regarding my lawful standing.
Oh yeah, and I would have suspected that, Alex, because you're pretty onto it, mate. Yeah.
So what I'm going to do is this week, before I even send the second letter, I'm going to send the actual affidavit addressed to the court as well, and attach a copy of the one that I sent to the department, and get the court to rebut it if they can. And if not, I'll be using that as well in my future letters, and I'll be making reference to that as well.
So when they arrived, as you ran us through the story at the offset of this presentation, you already had an agreement in place. So thus, they probably would have acquiesced to that. Therefore, you had layers of law which were beneficial to you in your tent embassy of security. And there they are, trespassing upon your right and the laws that you created between them and yourself.
That is correct.
Wow.
I can't remember the date, but
I just noticed the name there. I've dealt with that lady, Miss Catherine Campbell there.
Have you?
Also, the previous head of the department, which would be Renee Leone, she resigned 2 days after I filed in a PPSR in relation to a secured party, and sent her the information as her the one to inform. Interesting.
Yeah, so I sent it to those guys. I actually sent it to John Bradley. He's actually the secretary of the Department of Environment. So they actually already had that.
And it's green. So they certainly do. And it reflects that in the Office of Registrar for the Stefan Alex estate.
Yeah. Okay, so moving along, I'm going to make that, because I'm going to review that later. The court agrees and acknowledges that the Land Act 1958 has no force of law over living men and women whose lawful standing is under common law. As regards to the judicial powers, the magistrate agrees and confirms that she does not have the judicial power to proceed with this case or issue any orders in the absence of a full jury.
Alex?
Yes.
We're going to have a time out.
Told anyone how? He doesn't want to tell anyone.
That's okay.
I'm not entirely clear on what the reservation is. I do understand that people have gotten into trouble, but my understanding is that they got into trouble because they weren't doing it right. So I would love for Bill Turner to perhaps spill the beans on how he does that, because that'd be nice. Yeah. I've been looking into it for a few years myself, and I still haven't been able to. I mean, I know a lot about it, haven't done it, and I'm not fully clear on exactly how it's done.
Oh, well, it's about time.
Without getting into jail.
It's about time we put our heads together and got access then, hey?
I agree. I totally agree.
Yep. I don't think, I don't know though, Bill Turner, you can put him in a position of lots of questions, and he finds it hard to answer many questions. However, he's good at his presentations.
He is, yeah.
And, I wouldn't be surprised, if he hadn't accessed it.
Okay.
But that's not saying that he hasn't, and that's not saying people haven't, because I'm aware of people that have also around the globe, because I've worked with...
I've heard of a few, but I've also heard of people ending up in jail after they got the money.
Well, you don't want the money, you just want the usury of the credit.
Yeah, I guess. Yeah, yeah. You want to at least be able to discharge your debts.
Well, you discharge your debts, for example. You want a yacht. You get billed for the yacht. You send the bill to the treasury, and you get them to set that off. You know, you're not using money per se. You're just in
Yeah,
usury of the, as you are here to the. We have got dominion over everything. Yeah, I mean that's if
yeah,
you're
yeah.
standing in Christ.
Mm,
That opens up an onion layer, which gets really down to the nitty gritty of everything, really, to the crown.
mm, mm.
That crown being you, that crown being
Yep,
me.
yep. That's right. So we're at the end here. So the last section is judicial notice. Should you decide to ignore this request for further and better particulars and fail to provide clear answers under penalty of perjury, supported with valid evidence, and should you proceed with hearing this case or issue a court order, in the absence of such an affidavit, it shall be deemed that you are acting outside your judicial capacity and the order was not lawfully issued and is therefore of no lawful force or effect, and the officers of the court responsible and any other persons attempting to enforce such an order will be prosecuted to the fullest extent of the law. Finally, as per the other letters that I showed you, I take this opportunity to notify and remind you of the legal maxim which dictates that silence is deemed to be acquiescence, a concept that was upheld in this case. And then I like to put this at the end. I've only just started using this. This is a legal maxim. Expressed assent is that which is openly declared. Implied assent is that which is presumed by law. Unless express dissent is shown, acceptance of what it is for a person's benefit to take is presumed. That is a legal maxim. And then I signed it down the bottom there. So this is the first of 4 letters that'll be going to the Magistrates Court, as well as my living testimony in the form of an affidavit. This is the one that I sent to the department previously. And a very similar version of this will also be going to the Magistrates Court to give them an opportunity to rebut it. If they don't, by the time the case comes around, it stands as truth in law, and we can discuss it then.
Excellent.
So I guess my question is, how am I doing?
Well, yeah, good. It's certainly a bulletproof instrument. I mean, from the get-go, you've done the right thing. You've got your tents there on that land. You probably already knew that it was Crown land because you obviously questioned everything and know everything.
I had an inkling, yeah.
That you need to that pertains to your life. So you've made.
Well, actually, let me pull you up on there. I had an inkling that the Crown asserted ownership and control over the land because they usually do with any land that's within 25 meters of a bank of a river. But I do genuinely, in my heart, dispute their assertion that the Crown owns that land. I would strongly argue that the original sovereign nations of this continent actually own the land. And in the absence of any documentary evidence, in my opinion, that's still the case.
Well, how about if that is true, that the Crown does own the land? However, the Crown is not the trading company, but the Crown is you and the people.
Well, that too. In fact, I even brought that up to the guy when he was here. And I said, well, who's the Crown? We said, it's public land, blah, blah, blah. I said, well, I'm the public. So what's the problem? Anyway, but that didn't really go very far because, they don't have too many brain cells to rub together.
Well, you've questioned, the proof for the, which gives them authority and makes them crown or whatnot. But the question that I'd ask them to prove the claim is that, it would be that. But I'd go on to, that is all depending if you've corrected the record of the birth, deaths, and marriages in relation to the name. Because this leads me into something called the zygote, the phantom twin, which I've been getting around with the with the Christian appellation Daniel Luke. However, that is still the person. I should be going with Crown.
What do you mean?
Because Shoals isn't mine. There's the phantom twin. So what would be born or birth? The birth date would come back down to the time where we'll, of the inception of fertilization. So to take a man-made construct of a birth date would therefore make you godless at birth, right? But the zygote and the phantom twin, I cannot elaborate too much on this one because it's something that's just been put in front of me just recently that I have to now delve into and now study, because it's as you know, in time you go through different layers and you leave the old behind, and you look back in hindsight and go, oh my God, did I do that? Is that the way I handled my administration? So I'm at another level now, and it steers to the Crown. And when you mention the Crown, there's certain like bits of paper, which would be laws, etc., that bind the Crown, but a lot of them don't. And you'll find the ones that bind the Crown also state that nothing in this legislation or any instruments of their fictitious world pertains to the Crown. It can't be held to the Crown. And that's much like a man, right? A man shouldn't have to abide by or follow anything like that, but it states that in certain documents that in the ones that bind the Crown, it also states in there that anything else doesn't. And that's the Corporations Act 2001. And if I actually had a chance to, just trying to think. Yes, I do. Just a second. I'll bring something up. Where are we? So, all right. So, for example, every action is interference with privacy cause an adverse action done. Privacy Act of 1988, Commonwealth Fair Work Act of Fair Work 2009 of the Commonwealth. Contravening the Privacy Act of 1988 for serious and repeated interference with privacy, given an adverse action under Section 4, 13, 13B, 13F, 13G, 36, 67, 80Q, 83, 94A, 94H, and 94R in this Act, and Fair Works Act 2009 under Sections 37, 340, 342, 346, 351, 579 of that Act. And because are you the name or the crown that goes on the body, the name, corporate to make one whole? The use of the name Joe Bloggs is the conflict of interest, adverse action, interference with privacy. You are the crown living, your person John Bloggs is holding the office, the crown entity agency. Every time you use the name, your oath, you contract. So
in summary, that's saying that the straw men, all the straw men and women are actually the crown or part of the crown?
They're the agency.
Agency.
So you've got in some legislations, you would recite this, your body corporate. So you're the corporate of the body corporate.
Uh-huh.
But as I say, this is something that's new to me. So I'm only just sharing ideas, bounce back and forth. But there's an interesting video that I've actually got on my YouTube channel, which I recently have had nothing on there because I've been rather a private man for many years, and I'm only here now because it's called for. So I'll share that with you. It's a very interesting conversation with a couple of interesting gentlemen. You'll find that there. And, this recording, I'll perhaps, we'll leave this conversation out of it. We'll just stick to what we had there. And we can always just we can do a summary if you want in relation to that. I think we've basically summarised it anyway, really, through the question.
Well, in summary, I could just summarise like this. I sent 3 letters to the department, followed by a 4th, which was a private settlement agreement. I then got a summons. I have now commenced the same procedure with the court. And as well as that, I am going to send the living testimony in the form of an affidavit, which is this one here, to the court for them to rebut if they like, with a copy of the one that I also sent to the department. So that's the total of my paperwork. So by the time the case comes around, we'll see what they have to say.
Well, fantastic. Thanks for sharing that process with everybody.
Yeah, no worries. So do you think there are any major holes that could cause a problem?
And by the way, too, if I do get that up on my YouTube, I will blotch out that address and your date of birth too, all right, bro?
Yeah, please. Yeah, thanks.
No worries. That's if you consent, I can pop it up there for people's education.
Yeah, as long as the address is blocked out and the date of birth, that's fine.
Yeah, cool. Anything that is a little bit private, mate, I'll get rid of it. No worries.
Yeah, thanks.
Well, not putting in legal gives them a opportunity to fuck you over there in that realm.
Well, what I did do is this has legal in it.
Oh, yep. Legal notice of default, fantastic. And another thing as well, when you're setting some of these instruments, they're not an affidavit.
Yeah, I was thinking that too. Should these letters have actually been affidavits? That's what I was wondering. I mean, I am sending them an affidavit anyway, which is this one here. It says pretty much a lot of the same things, so it should still hold water, shouldn't it?
Well, I believe. I mean, when I say affidavit, I mean when I've collected on a commercial lien, that was certainly under an affidavit, Oath Act of 1867. But I'm just sharing my thoughts in relation to your question with these notices. I mean, you've already got a contract, you've got your layers of law, and now you're just basically noticing them considering the aforementioned. I think it would be pretty much binding, I'm pretty sure, because if we look at the notice, a notice is something that's there for you can use to get any redress on. So whether or not that's in affidavit form, I'm not sure. But you know what? The last lot of paperwork I've done from interlopers trying to meddle in and trespass upon my estate and whatnot, I've only done the same thing, bro. I haven't used any affidavits. I've just done notices also.
Yeah, but I'm wondering whether doing this instead of just as a letter, doing it as an actual affidavit would strengthen it.
Oh shit, yeah. Because in their system.
So how would the wording still be the same? Because it doesn't sound like an affidavit.
Well, if it was an affidavit, if you had put it under an affidavit, I mean, you'd make those points continue. So 1, 2, 3, 4, 5, 6, and then your section 2, 7, 8, 9, 10. So therefore, when we're talking about rebuttal, point for point, and then there can also be reference to the numbers of whatever it is that they've got an issue with, or something you might want to refer to them later. You can refer them to section 26, whereas now you cannot do that. You can only refer them to the notice, and then they're going, well, it's 8 pages. I mean, can you be more specific?
Yeah, I thought of that.
So, yeah, that would be the only change I'd see, which would be, putting them numbers for your points and your subsections, obviously, 1, A, B, C, D, E, G, then 2, etc.
So I'll change all those to, see, these ones here are numbers. these are my requests for them to provide. So, but the first ones were kind of like a summary of the version, my version of events that took place leading up to this point, and then they become numbers when I start making my requests. So, but yeah, I'll take your point. I will change them all to numbers. Do you reckon it should be just continuous all the way through, or should each section begin with the number 1?
No, continue it through.
Okay.
Yeah, continue it all the way through. Yeah, that's what I've done on a successful commercial lien there. It was up to about 256, but there's also about 8 different sections. So you'd have your subsections, you'd have your allegations, you'd have your damages, you'd have your tendering, you know, and then a whole lot of everything else, which basically leaves no stone unturned for them to, you know, use an excuse that, you know, it wasn't explained fully.
Yeah, okay. And if I were to convert this into an affidavit, so apart from changing the numbers, do you think the wording is okay? Or should that be altered to something else?
That's fine.
That's fine. And then basically, the only difference is, apart from the numbering, is get a JP or a notary to witness it. Is that it?
Yep, that's right.
Okay. Yeah. Oh, and at the top of it, it needs to say affidavit, correct?
Yeah.
Yeah, that's all it needs to say. It doesn't need to say anything else.
Well, I would go an affidavit, an oath, and I put the Oath Act of 1867 there because I, you know, I've either affirm or take oath under a section that the JP will read out of the Oath Act of 1867. You know, blah 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 blah. Yes, I do. You know, so therefore, when I'm autographing it, I'm swearing an oath or whatnot. So help me God.
Okay, so this will say affidavit of Alex Stefan and notice of objection, blah, 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 blah. Is that what it would say?
I'll just go up the top further. Go up the top.
All the way up to the top,
Yeah,
and then do this. Put affidavit up there. And then leave this as is here.
Yeah, that's it. I'd just do it, go up the top above everything and just put affidavit. If you want to go on Oath Act of 1867, that's up to you. But yeah, I'll just chuck that up the top and leave everything the way it is, mate. Yep.
And this can stay there and that can stay there.
Yep, everything.
Okay.
Yep. Because all you're doing really,
I
believe, by putting the affidavit on there, you're just strengthening that instrument. Therefore, it's a commercial one that can be used in commerce, you know, to fucking fist some assholes.
Okay, I'll do that. Yeah, I was wondering that. I was thinking it could actually make it stronger if it was an affidavit. So, yeah, I'll do that.
Yeah, because as I said, you know, I've done similar as well, you know, and I'm having a bit of a duel at the current time with the local regional council here. So their behaviour, actually, I'm not even going to bother. But I was going to bother, but and if I was actually going to put it on an affidavit. But I'm not going to bother now. You know why?
Why?
It's addressed to Mr. Daniel. No, what do you call it? What's that?
Hyphen.
No hyphen. Luke. Therefore, they're under the presumption that Luke's the surname that's joined to me, which it isn't, because I'm not. I have a surname Scholes.
That's good. Yeah.
So I'll just let that shit ride out, man. If they want to continue on, well, yeah, I'm not. I'm not a Mr. Luke.
Who are they? What are they doing?
It's quite an interesting case because back 18 months ago, I had a duel with them. They came up to, you know, tiptoed around the boundaries of the property where I'm at here, and I went out there to see what their business was, and it was in correlation to, because in between my place and the neighbour's house, there's something called an easement, which, you know, you can put an alleyway in there or whatever. So it's council property. Now, I don't know who it was, but someone like put bushes there and, you know, lawn clippings there. I mean, how dare they? Ashes to ashes and dust to dust. Terrible people. And they alleged that I'd done some illegal dumping. So they had all this paperwork and whatnot. And, you know, I questioned his authority from the start. You know, he was relying on the Local Government Act or
Yeah.
was, etc. And I sort of said, look, mate, you know, it's invalid. You got the colour of law and, you know, your ultra virus. I said, you got nothing and whatnot. So I established, you know, my standing and whatnot. And then I, being a diplomat and, you know, the executor of the estate, you know, I act accordingly. So I can't be out there foul-mouthing and whatnot. So, you know, we smooth things out from a bit of ego battle there to just a little bit of a chit-chatter and, you know, send him on his way. And I said that I will CC him into an email that I'll be sending to your principal. What was his name? Emmanuel. And I said, you perhaps will be back in a week's time asking me how you can help me. I said, but we'll see. I said, God bless you there, Emmanuel, and see you later. Sure enough, a week later, he came back and he said all that paperwork, etc., was, you know, they threw it all out. Don't worry about it. And how can I help you? I said, well, you can
Interesting.
just... yeah, and the interesting thing is, just recently, another agent by the name of Shane, you see, the agent before was Emmanuel. 18 months later, we have an agent Shane. Same thing, brother. Same thing.
Oh, really?
So if that case back then that I dealt with, and it pertains to the same thing, I mean, what are they, and in between time, I've set up an agreement. And when I speak of the, where are we? I'll just bring it up now, actually. And when we speak of the agreement, it's in relation to, you know, the High Court case 11 of 2015. If I quote, if you have an ABN and provide services for money, you are a trading company. End quote.
Yeah.
The ATO classes local governments and councils.
Hey, where did you get that from? Can I have that? I couldn't find that. I was trying to find it and I couldn't find it. Is there a court case or something that states that?
Would have to be.
I've been trying to find one. I've heard that there is, and I haven't been able to find it. I don't know where it is.
Ah, well, so if you put in HCA 11.2015, it won't give you a result.
Let me find. Well, so what is that? What's HCA? What is it?
I'd say HCA would be an acronym for High Court case or High Court Australia.
Yeah. Okay. That's true. Yeah. Forgot about that.
I've got HCA 11.2015. Give that a burl.
Space 2015.
Or perhaps you could also do a partial quote next to it to help the search out. If you have an ABN, perhaps put that with it. See what happens.
ABN.
If you have an ABN, yeah, that's a bit of a quote out of that case. So that might help the search result. I'm not sure. Anyway, while you're looking for that, and the ATO classes local governments and councils as ABN trading companies, right? Fair Work.
Here we are. Got it. Oh, that's from what's his name's website. That's good.
John's.
I needed that.
And then in relation to the Fair Work Act Section 35, quote, if you have an ABN and you employ people, you are a company. Okay.
Is that from this same thing, this same court case?
No. That there is from Fair Work Act Section 35.
Hang on. Don't move.
So that's the three. What
does it say? So what's the wording on it?
It's Fair Work Act, which is a legislation, Section 35.
And what's the wording of the quote?
If you have an ABN, and you employ people.
Okay. Do you have the actual document? Can you send it to me?
I'd have to look it up.
Yeah, okay.
It'll be somewhere.
That's right. I'll look it up. That's fine.
Yeah.
Gives me something to do.
So in respect to those three, I mean, you know, things don't have to be long-winded, etc. That's three things there that provide proof of claim within their regulatory system that they are.
I only have two here. What's the third one?
So we've got the ATO classes, local government as councils, and councils as ABN trading companies.
Oh, okay. Hang on. And what document is that from, or court case or whatever?
Yeah, I'm not sure.
The ATO class, what? Local councils,
Local governments and councils
local.
as ABN trading companies. Local governments and councils as ABN companies.
Okay, I'll follow that through with that tomorrow.
Yep, cool. Yeah, so that's what I've put there in relation to a lot of other points there. And
So
for
so in your sorry to interrupt.
you're right, brother.
I get excited. So in your letter that you sent to them, so you only sent it by email, and these are the three things that were the basis of your argument. Is that what you're saying?
Well, there's no argument. I was making a claim.
Yeah, that's what I mean. So, and based on these 3 points that you made, they backed off.
Well, they've agreed to them, bro.
Yeah, right.
I can send you what I did for the local council. It's pretty simple.
I'd love to see it. Yeah.
Yeah, it's what 1, 2, 10, 11, 13. So 13 points, and it gives them a place there to yes or no. Item 13, disagree because. So they got an opportunity to agree to the points that I'm making. Yes, if you agree. No, if you don't. And yes, and if you're going to disagree, we'll disagree because. Why? And they cannot, because we know that, truth and fact is something that can't be really rebutted.
Yep.
And if they, sort of thing. So that there formed the agreement. And then I'll strengthen the agreement with further terms and conditions to it, just to sort of, keep things, hunky-dory for the Shoals Daniel Luke estate.
So you just sent them one email. You didn't do the registered mail. You didn't do the 3 letters with the default notice and the private settlement agreement. You didn't do any of that. Just one email.
Mm-hmm.
Oh, okay.
Mind you, though, I mean, what you just spoke about is probably the best way to do it. I'm just get a bit lazy sometimes.
I'm just surprised. Yeah, that's great that you got such a good result so easily.
Well, I'm not sure. I mean, if we look at the bills of exchange, 1909, we look at delivery, etc. But there's also some other legislation there, perhaps, because I'm pretty sure the definition of an email is, kind of a delivery of some sort. So, and you've got your record keeping too. If you get into the intricacies of, sending something, you got times, IP addresses, and all this jargon that goes along with it. So, it's certainly proof enough of claim. But I mean, if I was to do something really officially, I mean, I'd take out the process, which we all know, and that would be under an affidavit. The initial one would be an affidavit.
Right.
And, your defaults, your final defaults. I remember with my commercial lien, the final default was actually notarized and passed on to a debt collecting company, a subsidiary of a debt collector from Western Australia, but they were here in Queensland, and passed on all the securities, aka the paperwork that was tied to the debt that was outstanding, by 150 days. And they were happy to take that debt on. They put out a financial tracer on Constable Christopher Shepherd also, and gave me a little bit of an idea about things there also. So,
did you end up collecting on that?
No, I didn't, because I haven't signed the agreement.
Which agreement?
The agreement for them to collect it.
Right. Are you going to do that, or is there a reason why you haven't done that?
Because I got what I needed from them, because they accepted it, and all I had to do was sign the agreement. So that proved to me that my lien was a perfected lien, and it wasn't classed as any gibbly-gob. So that's all I wanted from that.
Yeah.
Obviously, primarily I wanted for the Queensland Police Service to stop butting in my business and meddling in my affairs, which did happen. So that was primary the reason why I did what I did. They backed off. They didn't come anywhere near me. I could go, they'd like wave me through their breath testing stations. I could go speed past them, give them a wave.
Why is that? Why is that? They recognise your number plate?
Yeah, they knew me because my car's pretty original. It's a nice Fairlane gear.
Right.
There
Okay.
wasn't many around in the town that I put this in place, which was Hervey Bay in Queensland. It was only 3 days after that I put that paperwork in that Ian Fraser, a senior police solicitor from the Queensland solicitor company, called me up in relation to the paperwork, and he was very curious to know what I was doing with it. And I referred him to a section, let's just say 253 section of the agreement. And I urged him to take a look at that, and he did. And then you could hear him pick up his office phone, and he hung it up because that said that any interested parties showing interest into this lien debt will become part of the lien debt. And, obviously for him to call me, it had weight. Obviously, once I referred him and urged him to look at this section, it had weight. He ran for the hills. He probably rang up Christopher Shepherd and said, look, mate, you're fucked. I can't help you.
You're right.
So, from the offset, as far as the police interaction was concerned, I'm just talking gibbly gob, who cares, whatever, sovereign citizen kind of a guy. That once, I put it in and started following through with it, that's when it became apparent to them that this isn't gibbly gob.
Yeah.
And that's when they backed off. It's when you follow through with things to a point. I mean, even enforcement, that they will back off.
Let's have a discussion on that in our next call because I want to show you something as well. Okay, so it's getting late. I think it's almost 11 o'clock.
Yeah, cool.
Thanks for your time, man. I really appreciate it. I really enjoyed this call. And you've given me some really good tips. And so I'm gonna action those in my next letters and take it from there.
Bye.